If you have a bank account in the United States, a savings account in another country, an ITIN number, a green card, a visa, or even if you became a U.S. citizen after immigrating here, what I am about to share with you today could be one of the most important financial and immigration updates you hear all year. Because over the past several months, a growing number of immigrants have found themselves asking difficult questions. Questions about taxes, questions about bank accounts, questions about what information federal agencies can access, questions about whether the rules that existed for years are beginning to change, and perhaps most importantly, questions about how these developments could affect their families, their immigration cases, and their future in the United States. So before we begin, I want to make something very clear. This video is not about fear, it is not about panic, it is not about sensational headlines designed to make people anxious. Instead, this video is about preparation. It is about understanding the rules that exist today, understanding the changes that have occurred recently, and understanding what practical steps you can take right now to protect yourself and your family. Because knowledge is power. And when it comes to immigration and financial compliance, being informed can save you from costly mistakes that may take years to fix. Imagine this scenario for a moment. You have been living in the United States for years. Maybe you arrived on a student visa. Maybe you came on a work visa. Maybe you entered through family sponsorship. Maybe you have a green card. Maybe you have been filing taxes every year using an ITIN because you wanted to do the right thing. You work hard. You pay your bills. You send money home to help your parents. You have a small savings account in your country of birth that you have maintained for years. One day you sit down with an attorney to discuss a green card application, a citizenship application, or some other immigration benefit. During the conversation, the attorney asks a simple question. Do you have any foreign bank accounts? You answer yes. The attorney then asks whether you have been filing your FBAR reports. Suddenly you realize you have no idea what an FBAR is. That moment of confusion happens far more often than most people realize. And unfortunately, the consequences of not understanding these rules can be serious. Over the past decade, the federal government has dramatically increased its focus on international financial reporting, tax compliance, and financial transparency. What many immigrants do not realize is that some of these requirements apply even when the money involved was earned legally, reported properly, and maintained in ordinary savings accounts. In other words, you do not have to be doing anything wrong to create a compliance issue. Sometimes, simply not knowing a reporting requirement exists can create problems. And when immigration benefits are involved, those problems can become even more significant because tax compliance and financial history often intersect directly with immigration applications. Let us start by understanding why all of this matters in the first place. The Internal Revenue Service, commonly known as the IRS, is responsible for administering and enforcing federal tax laws. For decades, one of the fundamental principles of the IRS was taxpayer confidentiality. Individuals were encouraged to file accurate tax returns, report income honestly, and comply with tax laws with the understanding that the information they provided would generally remain protected. This policy helped build trust in the tax system and encouraged participation from millions of taxpayers, including immigrants who may not have had traditional immigration status, but still wanted to fulfill their tax obligations. For many years, immigration attorneys routinely advised undocumented immigrants and mixed-status families to obtain ITIN numbers and file taxes because maintaining a history of compliance demonstrated responsibility and good moral character. Filing taxes became part of building a positive record. It showed that an individual was contributing to society, following the law, and taking their obligations seriously. Those benefits remain important today. However, recent developments involving federal agency cooperation have raised new questions and concerns throughout immigrant communities across the country. As discussions about information sharing between government agencies continue, many immigrants are understandably wondering what information is protected, what information is reportable, and what information may be accessible through various legal channels. These are not simple questions. They involve complex interactions between tax law, privacy law, immigration law, and administrative policy. But understanding the basics can help you make informed decisions moving forward. One area that deserves special attention is foreign bank account reporting. Many immigrants maintain financial ties to their home countries. Perhaps you own property overseas. Perhaps you inherited money from family members. Perhaps you have retirement savings in another country. Perhaps your parents added your name to a family account years ago. Whatever the reason, foreign financial accounts are extremely common among immigrant families. Yet many people remain unaware that certain reporting obligations can be triggered when those accounts exceed specific thresholds. The most widely known requirement is called the Foreign Bank Account Report, or FBAR. Every year, thousands of individuals discover they should have been filing this report but never knew it existed. The requirement can apply to U.S. citizens, green card holders, and even certain visa holders who meet federal residency standards. If the combined value of foreign financial accounts exceeds certain limits during the year, reporting may be required regardless of whether any income was generated. What surprises many people is that the threshold is not based on annual averages. It can be triggered if the aggregate value exceeds the threshold even briefly during the year. A temporary transfer, inheritance, property sale, or family gift can unexpectedly create reporting obligations. Now imagine discovering years later that you should have filed reports that were never submitted. Suddenly you are dealing with penalties, compliance procedures, legal consultations, and uncertainty about how the issue might affect future immigration applications. This is why awareness matters. Most compliance problems begin not because someone intended to break the law, but because they never knew a requirement existed in the first place. Another important area involves FATCA reporting. FATCA, which stands for the Foreign Account Tax Compliance Act, created an entirely new framework for international financial transparency. Foreign banks throughout the world now cooperate with U.S. reporting requirements to a degree that would have seemed unimaginable decades ago. As a result, many international financial institutions already provide information concerning certain U.S.-connected accounts. This means voluntary compliance has become increasingly important because the likelihood of undisclosed accounts remaining unnoticed has decreased significantly over time. For immigrants, these developments create both responsibilities and opportunities. The responsibility is ensuring compliance with reporting requirements. The opportunity is the ability to correct mistakes proactively before they become larger problems. Federal programs have historically allowed taxpayers to address reporting failures voluntarily, often resulting in more favorable outcomes than waiting for an issue to be discovered during an audit or investigation. The key is acting before a problem escalates. Another issue many viewers have asked about involves ITIN numbers. Individual taxpayer identification numbers have helped millions of people comply with tax laws even when they were not eligible for Social Security numbers. For years, ITIN holders have filed returns, paid taxes, claimed allowable credits, and established records of compliance. In many cases, those records later became important when individuals pursued immigration benefits. Tax filings can help establish residence history, employment history, family support obligations, and evidence of good moral character. These records often become valuable pieces of evidence during immigration proceedings. That is why maintaining accurate tax records remains so important. Whether you're applying for a green card, renewing a visa, seeking naturalization, sponsoring a family member, or simply planning for your future, your financial history tells a story. It demonstrates responsibility. It demonstrates compliance. It demonstrates participation in the economic life of the country. Those factors matter more than many people realize. Let us also talk about something that creates confusion every year: sending money abroad. Millions of immigrants send remittances to family members in other countries. These funds help parents pay bills, help siblings attend school, help relatives access healthcare, and support entire communities around the world. Remittances are a lifeline for countless families. Yet rumors frequently circulate online claiming that all international money transfers are automatically suspicious or illegal. That is simply not true. Lawful remittances remain a normal and important part of the global financial system. However, large transactions, unusual patterns, and certain reporting requirements can attract attention from financial institutions. Understanding those reporting systems helps eliminate confusion and reduces anxiety. As we continue through this discussion, I want you to remember something important. Every situation is different. A student with a small overseas account may have different obligations than a business owner with international investments. A green card holder may face different reporting requirements than a temporary visa holder. An undocumented worker using an ITIN may have concerns that differ from those of a naturalized citizen. This is why general information is helpful, but personalized legal and tax advice remains essential. The good news is that preparation can solve most problems before they become serious. The individuals who experience the best outcomes are usually not the wealthiest or most connected. They are the people who stay informed, keep accurate records, ask questions when they are uncertain, and seek professional guidance when necessary. They do not wait until a problem appears. They prepare in advance. And that preparation gives them confidence, stability, and peace of mind as they continue building their lives in the United States. So in today's video, we're going to break down everything you need to know about IRS rules, FBAR reporting, FATCA requirements, ITIN compliance, foreign bank accounts, immigration implications, tax filing obligations, remittance concerns, and the practical steps you can take right now to protect yourself and your family. By the end of this video, you will have a much clearer understanding of what these rules mean, who they affect, and what actions you should consider taking next. Because when it comes to immigration and financial compliance, uncertainty is your enemy, but knowledge is one of the strongest forms of protection you can have.